SJC-11913, Commonwealth v. Robert Wade.
Okay, Attorney Pumphrey.
Good morning, may it please the court. I'm Janet Pumphrey for Robert Wade again. Robert Wade proved every element required by Section 7, and the Superior Court so found. The courts and the Commonwealth's theory that some extra statutory element can defeat testing it's untenable.
Well, the Superior Court didn't find that. I thought the Superior Court's decision was based on, not on finding one of those elements.
It was based on, allegedly, he said it was based on 4, but by the time of that testimony, we had waived 4. We were only proceeding on prong 1. The differences among those prongs, I set this out in my reply brief.
Well, was that right? I mean, so that the, I thought that there was a question about whether or not that an effective assistance of counsel argument could be waived.
That's also part of it. That's also absolutely part of it.
Well, I don't know what Judge Healy was doing. Was he doing it on both of those?
On both of?
Was he doing it on the unavailability of the test earlier at the time of trial, as well as on ineffective assistance of counsel?
What he said was, it was only really the prong 4 that a reasonably effective attorney would have ordered the testing.
So it was only on 4. He didn't.
That's what he said.
But I mean, didn't he ultimately just decide that what mattered was, as he put it, the primary reason?
Primary reason, that's absolutely right, which is really an external, extra statutory reason engrafted upon the statute, which is not, no place in 278A are the words primary reason or primary cause used.
So on that theory, it could have been either that it was the availability wasn't the real reason, or the unavailability wasn't the real reason, and that the counsel was not ineffective because he wouldn't have used it anyway.
I think that's right. I think I understand.
So I'm just trying to go to, I mean, I'm not really sure which of these prongs.
I was
really
proceeding,
play.
during that testimony, I was proceeding only under prong 1, that the testing that's available today is significantly more discriminating than the
But
testing.
Judge Healy, I mean,
Judge
I
Healy
understand that
he
you
understood
did that, but he didn't accept that. That's all I'm saying.
He didn't accept it, but he understood it. If you go to...
He may have understood it. He just didn't accept it.
He didn't accept it. I mean, he asked many, many times what I was doing, and I kept repeating it. I'm just proceeding under prong 1. So he did understand it, but I guess you're right, he didn't accept it.
I mean, he took the structure of the statute to be that the word reason seemed to him to have to be the real reason.
The real reason, the primary reason.
No matter what reason,
No
even
ma-
if it is one of these reasons, if that wasn't your real reason,
That's
it's
exactly
no good.
right. That's exactly right. And so this primary reason could theoretically be any reason. The difference
It
is...
was the real reason.
It was the...
If it was the real reason, according to
Well,
Judge.
it's outside of this, I mean, that's what the judge believes, but it's
That's what I'm
it's certainly
saying.
not one of the reasons in the statute, this primary reason.
Right.
Of those 5 prongs, the only prong that requires an inquiry into the past is prong 4, to see exactly, at the time of trial, what a reasonably effective attorney would have done. The other 4 prongs all involve future developments in the law or the science, and with prong 1, the test had not been developed at the time of conviction. Under this theory, the Commonwealth's and the Superior Court's interpretation, any of those other 4 prongs would be impossible to satisfy because they could all be subsumed under prong 4, or this primary reason. The Commonwealth's argument goes, and this is on their brief at page 21, the development of a new test is only half of the defendant's burden because Section 7 requires the defendant show that a new scientific development is the reason that the physical evidence was not tested. That would require defense counsel to be prescient in 1997 and to know that in 2014 a new test would be developed. And that
Well, I mean, the Commonwealth also argues that actually STR testing was available.
That's right.
Certainly by the time of trial.
Exactly right.
And I guess this is a technical question, and maybe one of the experts explain it, but I did not think that, is it Dr. Ladd? Was that
Dr. Ladd.
Yeah. Well, here's my question. It seemed to me that, I wasn't clear that the PCR testing that was clearly available, I mean, you know, whether the STR, yes, by the fall of 1997, but that's, of course, when the trial was. But is it, I mean, you're different than Donald in the sense that there was no testing at all. So
That's
I'm just,
right.
so I'm wondering, does that make any difference, that you had no testing at all? It's not clear to me that the testing that was available wouldn't have done what needed to be done in this case, but
This case is really, at this point, morphed into Donald, I would suggest, because Donald obviously had DNA testing done then, at the kind of DNA testing that was available then. But in Wade, it was only serology testing that was done. And I think even the court found...
Right, but DNA testing that was available, you know, before trial, I'm just not clear what the 13 loci, or loci, however you say it, that anything in your case turns on that, as opposed to DNA versus serology.
Right. Well, the Superior Court found that today's DNA testing is far more discriminating than what was available in 1997, and that was based on Dr. Ladd's testimony that two statements. The state-of-the-art testing in 1997 was DQ alpha, which would produce a discrimination result of approximately 1 in 1,000. With contemporary DNA testing,
Didn't you say something about 1 in several thousands?
1 in a few thousand.
Okay.
With contemporary DNA testing, you can get numbers matched probability statistics of better than 1 in a trillion. So that's significantly more discriminating.
Can I just ask you to address what I think is an underlying concern here, which is that under that first prong, that it would, one presumes that the science will continue to get better and better and better and better and better and more and more and more and more discriminating. Is the Commonwealth right to be concerned about the fact that under that first prong, this will always be available to the defendant, to a defendant? You had this kind of testing done, but now there's this newer kind that's far more discriminating, so I have a right to have it tested.
Well, I think at some point that the court certainly could draw a line that 1 in a trillion is incredibly discriminating testing. I wouldn't want to suggest that defendants can continue to come back and come back and come back because, and the other thing too is there are not that many people that this statute even applies to because DNA testing was so prevalent after 1999, 2000.
Yes, but as Donald shows,
That's right. That's
right?
right.
It keeps
that's
coming
absolutely
back.
right. But the difference in Donald is 1 in a few thousand to 1 in a trillion. The Commonwealth's argument is at odds with legislative intent. In Donald, this court said that the purpose is to allow testing to more sophisticated forensic and scientific methods than were available at trial. The legislature did not intend to bar access to new forms of testing. Also, the Act makes clear that that notwithstanding an incriminating statement to either the police or a plea of no contest, those should not prohibit testing. And in this case, it was an incriminating statement made by a defense counsel. And certainly you wouldn't want a person who talks to his lawyer should not be on a different footing from a person who confesses.
Can I ask you this question about that? Is there, I know that you objected and continue to object to Judge Healy's requiring Mr. Wade's lawyer to say what the conversation was. Is there any, where would you, assuming somebody comes forward with a prong 4, is there somewhere that you would say that's permissible, but this isn't? I mean, is there some line that you would draw?
Absolutely, because as I argued in my motion in limine to preclude defense counsel's testimony, and I argued in my motion to strike his testimony.
Well, here's my question.
Yeah.
Is there any piece of the testimony that in your view would be permissible, or you think none of it should? He should never be
He should never have been called to begin with, and that was my motion in limine, because it doesn't matter what my argument was then. It doesn't matter what the trial attorney did. It's what a reasonably effective attorney would do. The trial attorney's inquiry into why the trial attorney didn't do this is a subjective inquiry. He didn't do it himself, but the standard should be, and the statute says, a reasonably effective attorney. It's an objective standard.
Okay,
Let's take the case, not dissimilar to this case, but a case tried in the 1980s, a rape case. The defense is consent. It fails. 20 years later, the defendant says, there's now testing. I want that DNA tested. Just, does he get it because it didn't exist back in the 1980s, even though identification was not even an issue?
I would suggest that he gets it. With a change of in fact, the statute.
And he gets it without any assessment of
there's still the
strategy underlying the case and the facts. It's just, well, the test didn't exist in the 1980s. It exists now. Therefore,
It exists now.
Voila.
But that, I think, is the point of the statute, is to allow testing. And there are other safeguards in the statute, in particular, the affidavit from the defendant that he is actually innocent of this, notwithstanding what he said in the past. And then, I lost my train of thought.
And then the second
Well, what
stage,
about,
of
what
course,
about
where you have a
paragraph
hearing.
4, that the requested analysis has this is section 7,
Okay,
the findings that the judge has to make. I mean,
that's exactly right.
the identity in the example that Justice Carter gave you is not an issue. So why would the test be important?
Well,
for that
perhaps the future defendant would not get past that. There are definitely safeguards in the
Oh, no,
statute.
the defense says, I actually didn't do it.
Yeah,
The defense was consent, but I didn't do it.
yeah,
And now there's a test, and I want the test.
yeah.
So, but in this case, consent was a defense, yes? In your case?
Consent was defense.
Because he was
that's-
caught naked in the room.
That's
with the
right.
victim.
And as I argued in my first motion for a new trial about more than a decade ago, which never got before you, is that was a very misguided defense, because the defense counsel himself brought out and basically proved that the victim had Alzheimer's disease, and she was incapable of, and the jury was instructed, she was incapable of consenting if she had Alzheimer's. And that was the defense theory, as misguided as that was.
How could it be misguided?
Well, because if she had Alzheimer's, and he's trying to prove she has Alzheimer's,
Okay,
and
so client tells lawyer, I did it, all right?
client tells lawyer.
I did it. I had sexual intercourse with her. She consented.
just this is hypothetical.
This is not a hypothetical,
But
it's
in this case,
actually.
that's Robert Wade would object to that.
Oh, I'm sorry. Maybe I'm misreading.
But let me get back to Justice Botsford's question. When you talk about a reasonably effective attorney, doesn't that mean a reasonably effective attorney in the circumstances? And
That's right.
And doesn't the
That's exactly right.
circumstances, aren't the parameters of in the circumstances what this defense lawyer knew?
Well, I think that's what the single justice thought, that perhaps this attorney could add something to that question.
So how can the question, I mean, why is it just patently wrong to call an attorney for all purposes to testify in these circumstances? Can't some limits be put on what the attorney might say? And if so, what are they?
My plan had been to call Attorney Elliot Weinstein. He tried one of the major cases in the late 1990s, and he was going to testify as an expert witness as to what he would have done in the circumstances. And what he had available to him was a testimony from the trial and the police reports.
And I take it, if he had testified, it would be a perfectly permissible question, hypothetical question. Assume that your client told you that he had sexual relations with
That's
the
right.
victim.
That's right.
What would you do?
I think it would be a permissible question.
And if he answered, I wouldn't test, where would you be?
Yeah,
I mean, but the thing is, on your theory, you would never know that, right?
you would never know that, and you would never know that. And under the facts of this case, you shouldn't know it, because the way the breaching the attorney-client privilege played out was it was absolutely egregious.
So in your view, this question in small Roman numeral 4 can be adequately addressed through the use of expert testimony?
Absolutely.
And you don't need to call the defense lawyer?
That was my argument in the motion in limine and motion to strike. The piercing of the attorney-client privilege was extreme judicial overreaching. It was excessive, it was inexcusable, and this is how it played out. The Commonwealth continued questioning. The witness continued to refuse to answer. I continued to object. The judge ruled that that Wade had waived his privilege. So I waived prong 4. The prosecutor said, I have no further questions. The court would not accept that. The court looked to the attorneys for an answer, but the prosecutor didn't continue with questioning. And the court turned to the witness and said, you were ordered to answer the question. Did you have sex with the victim? And he did answer. Again, that is certainly a judge can ask a question of a witness, but this was biased, it was prejudiced, and it was overreaching.
Well, I mean, would you concede that if Section 4, prong 4 was in play, this would be perfectly appropriate?
No, I don't know, no.
Can you assess whether counsel has been ineffective if you don't know what counsel knew
Knew
from
at the
his own
time.
client?
I think that the defense counsel's continued answer was that he had available to him all of the police reports, all of the witness interviews that he had done, and I don't think that attorney-client privilege should be breached under any circumstances whatsoever.
Well, isn't it almost always breached when the claim is ineffective assistance of counsel, that my lawyer didn't do something I told him he should have done, or?
Well, that's completely different from this, because in this case, if it's an ineffective assistance of counsel case, it's the defense putting forward an argument. In this case, we moved in limine to keep this argument out. It was the Commonwealth that subpoenaed the witness, and so we had nothing to do with putting forward this argument.
And all of that would come up in the second stage of hearing of motion for new trial.
Right.
All of these issues, if the screening gets you to that point.
Right.
One last question. Would it be appropriate if if you're talking about Section 4, to limit the questions to the attorney about tactical decisions? Would that cross the line as far as you're concerned?
I think the question could be asked, but again, the attorney-client privilege should be sacrosanct. It should not be. And the answer that defense counsel continued to give is, I used my best judgment, and this is what I thought with what I had. And I think that's really as far as it should go. But my client told me this is just very much over the line.
Thank you.
Thank you.
Good morning. May it please the court. Mary Lee, Assistant District Attorney from the Plymouth District for the Commonwealth. The issue in this case is a new one for this court. The prior cases dealt primarily with Section 3. Clark was a Section 7 case, but they didn't have an evidentiary hearing. So the question before the court today is, what is the meaning of Section 7B3, where it says the defendant must show that the absence of testing is for any of the reasons, I'm quoting that, in Section 3B5, subsections I through V. That section is particularly important. I went into some detail into the legislative history of that section for this court. That section was added by the legislature. It wasn't part of the original draft in
Right,
Senate
but the,
753. As drafted by the BBA.
And you do that, and one of the amicus briefs, I think it's the Innocence Project, sort of takes a different take on that legislative history. So it just wasn't, I appreciate the fact that the change did occur. I'm not quite sure how to read what it means. I mean,
Well,
was there any discussion on the floor or anything like that? Or do you know?
I attempted to do due diligence. I don't have minutes.
You always do due diligence, Ms. Lee, always.
I went to the State House Library. I went to the Joint Committee's office. I asked if there were minutes. They told me they did not have any either other place. They suggested I go on YouTube because some people post them, so I did searches on YouTube. It would be an unofficial record, but I found nothing. I can't say that it doesn't exist somewhere in someone's possession, but I've found no official record and no written record, and I have not been able to locate an unofficial video. So having said that, I've attempted to do my due diligence. I don't know if SJC
I'm not
made a
being
request
critical
to
of you, I
get a
just didn't know
better
if there was,
answer.
if you had located anything. No.
So what we get from that is that the original draft, as drafted by the BBA, and they've filed an amicus in this case, didn't have that for any of the reasons in 3B5. And it just had to show that the testing wasn't done. And so whatever other amendments were made at the same time, that amendment increased the defendant's burden at the evidentiary hearing.
But the section 7, what section 7 doesn't do is incorporate into it the because of that's in 3B5.
Right, and I agree,
So
the because of is above that, but for any of the reasons, I mean, throughout the amicus briefs and throughout the defendant's brief and reply brief, they keep saying, well, the Commonwealth keeps asking for the reason why the testing wasn't done. It's not me asking for the reason. The legislature said the defendant must prove that this testing wasn't done for any of the reasons. And this court construed that language in Donald in the context of Section 3 to say that the defendant must show why the more advanced testing he requests was not conducted at the time of conviction. This
But
court,
because it doesn't exist.
well, that, if
Isn't that
that's
a
the
perfectly
reason,
fine reason?
if that would be,
It have to be the reason, the one and only reason, the major reason, the primary reason, or a reason?
I think,
A
consistent with
justification.
justice, it has to be the true reason.
Well, why?
Because a fake reason
Not a fake
is
reason,
a
it's just
sham.
one of the reasons.
No, I suggest, if you look at counsel's testimony, the fact that a new test is now available, it doesn't have anything to do with why it wasn't done. At A365 of the defendant's appendix, the defense counsel says at line 20, I did not want a DNA testing on that. And then if you move to Appendix 380 to 381, he was asked, starting on 379, the question was, if you had the opportunity to get a test that was more discriminating than the blood grouping or the available DNA at the time, for example, STR13 loci DNA, would you have gotten that testing? This is page 380, line 4. I would not have. And the reason was he thought it would inculpate his client. And I would suggest that saying that a new test has been developed is not true. That is not the reason the
It's
testing
true that the
wasn't
new
done
test
here.
that didn't exist at the time. It is true.
Well, I make a claim on that, which I
understand that, but I mean, the
so
judge found that it
without
was, so-
conceding that point,
Right.
I would say that the defendant's attorney did not want the more discriminating test that was in existence, available, commercially available, and admissible STR DNA. He testified to it, and he didn't get it, and that's why this case is not like Donald, where they did get the best test possible.
Let me ask you this question. Let's say that Ms. Pumphrey, in making this motion, had never raised 4, never, and had only raised 1. Would you, at the hearing on it, would you be able to ask anything? Would you be able to call the attorney and say, what was your real reason?
Yeah, I believe the Commonwealth would, yes. And the reason is that language for any of the reasons in Section 3B5. And here is why. Because this is an evidentiary hearing, the defendant has the burden of proof by a preponderance of the evidence, and therefore, if the Commonwealth can show by more convincing evidence that a different reason not enumerated in 3B5 exists, and that is the truth, and that is justice, that the defendant made this strategic choice that any reasonable, effective attorney would make, then that the judge would be well within his discretion in hearing that evidence to make the finding that I don't credit that you would have gotten the best DNA testing available. I credit that you did this on purpose.
But it's $1,500, right?
500 to 1,500.
The amicus puts in the cost of what the tests are.
I mean,
So how,
That's not part of the evidentiary hearing in this case.
so why can't you, assuming that you're right, you call defense counsel, trial counsel, And why isn't it enough that you go through the 5 criteria in 3B5 and say, did you do it or did you not do it for this reason? Did you not do it for reason number 2? Did you not do it for reason number 3? And assuming that the lawyer says, I did it for none of those reasons, end of questioning. You don't need to ask him what the defendant told you, do you?
That's a possible way to do it, but that does not, I think, infringe any less on attorney-client privilege. These, particularly subsection 3 and 4, require the knowledge of the attorney at the time, even to make the determination of under Wade that a reasonably effective attorney, regardless of the effective assistance of this attorney, you need to know the circumstances presented to counsel at the time in order to make that analysis. And 3 goes specifically to trial counsel's knowledge.
So under your analysis, the Commonwealth could always call trial counsel and ask him what the defendant told him.
In my analysis, the Commonwealth could always call counsel to find out what his reasoning was in not getting testing that was available at the time.
But isn't that always going to lead to a question, what did the defendant tell you?
I don't know that it would always lead to it. I think you can see the Commonwealth approach this cautiously, and by the Commonwealth I mean me. I approached this cautiously. I asked him what things he reviewed. He talked about the police reports. He had Elliot Francesca, who's the eyewitness, interviewed. He read all the police reports. He interviewed his own client, and he made the determination based on that. And so it was a slow progress to where we got to that point, but having gotten to that point about he didn't want DNA testing on it and he didn't want 13 loci or a more definitive test in that case, it begged the question why, and that's when the judge said, I find this is relevant. And he said, I find the privilege is waived on this.
And then the judge asked the question.
No, what happened was I had asked the questions, and then when I was getting no answer from counsel, I continued to ask questions. The judge said, wait a minute, what are you doing? Are you waiving your question? And I answered, I do not waive this question to counsel. I consulted with my sister who was presenting with me at the evidentiary hearing, and then I said, I do not waive this question. I asked the question again. We got no answer. I said, I have no further questions. That was my last question. And then the judge tried to come up with a remedy. My remedy that was suggested and rejected by the judge was that they draw an inference against the defendant that would prevent him from meeting his burden. And the judge said, I think the question and answer are relevant, and I want to hear it. And he's the fact finder. And so I asked the question again, and that's when the defendant's attorney said that his client had told him that he had sexual intercourse with the victim on the date of the offense.
But you asked the question again?
I asked the question after the judge let me phrase it. I said, should I ask it exactly again? I think the witness, trial counsel said, could I have the question again?
Didn't the judge said, order him? He didn't just answer.
The judge ordered him.
He said, you have to.
Oh, yes. Yes, it was very clear he had to answer.
You know, could you help with this? I'm really having trouble understanding how it is that the first doesn't become obliterated by, or whether everything becomes an inquiry by of whether the counsel was reasonably effective or ineffective. I mean, why doesn't this all sort of just become? It's always an inquiry as to whether or not a reasonable lawyer would have done this, because I mean, if you have to get behind 3B51, which is that one of the listed reasons is that at the time of the conviction, the requested method of analysis had not yet been developed. If you get behind that by, okay, it hadn't been developed, assume that that's true, assume that it hadn't been developed. But then you have to get behind that and say, yeah, but would you, even if it had been developed, would you have sought it? Aren't you really asking the fourth prong and no longer just that first?
Well, I think that instead of looking at the broad array of cases that might come before this court on this issue, if we focused on this case is particular because there was DNA analysis available at the time.
Yes, but...
And they didn't get it.
But
so the fact that there's another new test that might be developed later than trial, it begs the question, why didn't you get the fantastic test that was so much better at the time of trial? And so I think in the context of this particular case, it's that absence of the highest level of testing at the time of trial.
Going to always be the question, I mean, suppose we got a trial from 1975 that comes up, and there's just no question that DNA testing wasn't available, but serology testing was available, and that wasn't done. So then the question becomes, well, why didn't you get the highest level of testing?
I think
Is that
that's...
always the question? And so why doesn't that become...
No, I don't, because, I'm sorry to interrupt.
Yeah, so I'm really having trouble seeing the difference between reason 1 and reason 4.
Well, this is the difference between Wade and Donald, because Donald got the highest level of testing available at the time of his trial, and yet this court in Donald said that the defendant has the burden to show why the more advanced testing was not conducted. So it will be the issue at the evidentiary hearing if, you know, if counsel said, I wanted better testing, but there was nothing else available, then that would meet the burden, and nothing more would be needed to ask of counsel.
So you always get to ask something other than was the requested method of analysis not yet developed?
You always get to ask the true reason why the testing wasn't done.
And what's the, I guess I'm wondering what the difference, doesn't this just morph into a 30B motion of ineffective assistance?
No, I don't think so, because the defendant could have presented evidence that a reasonably effective attorney would get the testing even in these circumstances, and they did not do so. They never called Attorney Weinstein. They presented this under, this was originally presented under 4, and then because there's no waiver of any of the provisions permitted, they were able to add in one.
You say that Section 15 means that, and I really don't think that's what it means.
Well, then at the end of the hearing, at the closing arguments, the defendant withdrew his waiver of subsection 4 and put it back in play. And I can't object to that because the statute doesn't permit me to say, I won't call this witness if you don't go under 4, because they can always reintroduce it. Their waiver is meaningless under 278A, and the analysis requires the judge to find the true reason why the testing wasn't done. The legislature put this burden on there, and this court, as you found in Donald, has to respect that language. Under Article 30, separation of powers, this court cannot relieve the defendant of his burden of proof in this, regardless of what the overall purpose of the statute is, because the statute would not have passed without adding in for all of the reasons, for any of the reasons in Section 3B5. And the Commonwealth agrees with the legislature's assessment of that burden of proof as required for finality and for its assessment of the financial costs of the statute. And so I would suggest this court is subject to that statute, as you've already found you are in Donald under subsection 3. And I would ask you to affirm the judge's order in this case.
Okay, thank you.